Hey y'all, so this is just a quick video to catch you up regarding the latest filing that Katie Joy Paulson filed on Friday, March 20th. She filed her motion in response to 7M's motion to amend the complaint. Now, we talked about this in another video. We went over it briefly in a live stream. If you did not watch the video that I put out a week or so ago, go check it out. It's still up on the channel. It explains a little bit more about where this case is and what we were thinking. And it turns out that pretty much what we were thinking is what Katie Joy did, other than I really didn't think that she was going to respond to this motion. I thought she was going to wait for the judge to make a ruling and then file a motion to dismiss. But Katie Joy did. She filed a motion opposing 7M's motion to amend the complaint. So we're going to take a look at that and see what her argument is. I'm going to try to make this one quick. So let's get into it, y'all. Okay, so what we talked about before was this case is somewhat at a standstill. The judge has a lot of rulings to make. And one of the biggest things that we talked about was this motion to amend complaint that 7M filed in February. It did not appear as though Katie Joy was going to respond, as we did not see a response, and it looked as though the time had lapsed for her to do so. But there was another hearing that was held. And at that hearing, she might have been granted some extra time because then the next hearing for this motion to amend complaint was set, and that hearing is set for April 3rd. So once that was set, the judge may have granted, or obviously did, but regardless, Katie Joy filed her motion opposing 7M's motion to amend complaint on Friday the 20th, which falls exactly 2 weeks before the motion hearing. And I'm pretty sure that 7M has a lot to say in response to Katie Joy's opposition. And so we're going to go over what Katie Joy has said. And again, we should see a reply from 7M. So I suspect we'll see a reply brief soon, and we'll go over that whenever it does. But let's take a look at what Katie Joy had to say in her memorandum of law opposing plaintiff's motion to amend complaint. As a reminder, in 7M's amended complaint that they're proposing to the judge, it went from like 84 statements from the original complaint. This amended complaint has 212 statements that 7M is stating Katie Joy made that are defamatory. So that change has set Katie Joy off for a multitude of reasons. And we talked about it in the last video and on the live stream as to what her feelings were going to be about this amended complaint. And seems we were pretty much on point. And here's what she's arguing here. I'm not going to read this word for word. I'm going to try to get through this as quickly as possible to give you just the basics of what Katie Joy is arguing. But as always, feel free to pause and read it in full as you wish. But to get through it kind of quickly, I'll try to summarize the best I can. But Katie Joy respectfully opposes to 7M's motion to amend the complaint. She stands by her reporting. She says that she reported on matters of extraordinary public concern, which is alleged cold activity, financial exploitation, and sexual abuse by plaintiff Robert Shin. And the federal indictment of Shin has vindicated that reporting. So what I wanted to point out mostly here is she is stating as a fact that Robert Shin has been indicted. Now, does she know something we don't know? I find that hard to believe. Okay. From everything that I can tell, Robert Shin has not been indicted. Okay, so I'm interrupting here. I have to put an edit in because as I was finishing this video up, I was at the end of it at night and was going to finish it this morning. And I was informed that Katie Joy filed 2 filings. One was an amended memorandum of law opposing plaintiff's motion to amend complaint. And in addition to that was correspondence to the court from Jennifer Moore. And in this letter to Judge Willis, Jennifer Moore basically says that they had to file an amended memorandum of law opposing plaintiff's motion to amend complaint because the filing corrects reference in the memorandum filed on March 20th in which the term indictment was used where investigation is the accurate description. She then adds, there has been no federal indictment. So how this oversight happened, you guys can come up to your own conclusions. The only conclusion I can think of after all the different scenarios is just pure incompetence. I think they truly thought Robert Shin was going to be indicted, and they drafted this motion accordingly. However, whether it was drafted by Jennifer Moore, by Katie Joy, or by someone else, it was signed off by Jennifer Moore. That was on Friday, whenever this was filed. By Saturday afternoon, obviously this was discovered, the amendment was made, and it was refiled. I do know that some judges do not like situations such as these. I don't know how Judge Willis feels about situations such as these, but it happened. Here's the amendment. And going forward in this video, you will hear me as I read the original filing where they used the word indictment throughout. So keep in mind that there was an amendment. The word indictment needs to be replaced with investigation. So when you hear me say indictment, I'm not going to correct myself moving forward because it's an older recording, right? I recorded this last night before I saw the amendment had hit and was on the docket. So replace the word indictment with investigation. Okay, that's the end of this edit. Back to the pre-recorded video. If he was, Katie Joy would be boasting and she would have blasted it everywhere. So why, right off the bat, she said that she was just reporting, an extraordinary public concern about this alleged cult activity and that the federal indictment of Shin has vindicated that reporting. I'm shocked that this is in here, especially in this manner, because if he was indicted, there would be a lot more information following this statement that would guide the judge to see his charges, etc., to just blatantly say the federal indictment of Shin. It has not happened. So I don't know. Did she write this hoping that by the time this gets to the judge, he will have been indicted? I don't know. But why would Jennifer Moore be so irresponsible to sign off on something that clearly has a false statement? I believe that Katie Joy has drafted a lot of the motions and other filings, and Jennifer Moore has signed off on them. By reading this, it is my opinion that this is not Jennifer Moore's writing. As we go through this, you may or may not agree. I can't say for certain. I am guessing, and I have a feeling, and Katie Joy even said herself that she's talking to other quote-unquote companies to help her with this situation. Did she have another attorney draft this? And this was put in there and not reviewed by Jennifer Moore and left in there. Maybe they drafted this with the hopes that, okay, yeah, he was indicted. Here you go. But he has not been. Why would Jennifer Moore sign off on something such as this or write it herself if it has not happened? This isn't the only time within this filing that they refer to the federal indictment of Shin. Maybe she's trying to set her own attorney up for failure. Who knows? Who knows? Maybe this will cause Jennifer Moore to be kicked off the case and then there'll be a whole restart and she'll lose her licensing. I don't know. But then it says, plaintiffs have presented no factual basis to support any of the claims they seek to add or replead through the proposed Second Amendment complaint. This court's December 16th, 2025 order on reconsideration authorized 7M to move to amend their complaint in order to specify the statements which they claim are defamatory. If you remember, we've talked about this before. In that ruling, there were 33 statements that the judge said, and then again, this was Katie Joy's reconsideration of the summary judgment ruling. And the judge said, okay, I can agree, Katie Joy. There are 33 statements that, sure, maybe need to be expanded upon and clarified. So 7M, you can move the court to amend the complaint. And so that's why we're here. The directive addressed the 33 statements dismissed for lack of specificity. So those 33 statements, which the judge said, yep, they're a little, say ambiguous. Go ahead, 7M, move the court to amend. And Katie Joy is saying that it did not authorize 7M to, number one, replead 46 statements already dismissed on the merits or for non-specificity. And we'll get into how there's 46 statements here in a second. Number two, rewrite 12 statements that survived summary judgment. Number three, add 8 entirely new publications from the original complaint period that were available but never pled. or 4, add 119 statements spanning 3 additional years of protected speech. Yet that is precisely what 7M has done, expanding an approximately 85 statement complaint into a 212 statement pleading without presenting a shred of evidence that any newly specified or newly added statement constitutes an actionable, verifiable, false assertion of fact about a named plaintiff. And we have gone over the original complaint, how it compares to this amended complaint. And once this is granted, if it is granted, we'll go over whatever statements, if all 212 survive, we'll go over those 212 statements that Katie Joy has made that 7M claims are defamatory. So as a quick recap here, in the original summary judgment ruling, there were 13 statements that the judge tossed, okay? They were dismissed because the links that were provided for the judge to access those statements, the links did not work. They were not dismissed because the judge said, yes, there's no question that these are defamatory or not defamatory, therefore, there's no question they're being booted. That's not what happened. They were dismissed because the judge could not access the links to determine whether or not they could be considered defamatory. Katie Joy was unhappy with that overall ruling that she did not win in summary judgment, so she proposed to the court, she asked if she could file a motion to reconsider summary judgment, and the judge said yes. So Katie Joy filed a motion to reconsider summary judgment, and within that ruling, the judge saw 33 comments that she could agree with Katie Joy that needed some clarification. So ultimately, those 33 would be dismissed with the option that 7M could amend. And that is what they did. So that is how we get 46 statements. We get 13 from the original ruling and then these 33. Okay, moving on. The court should deny the motion in its entirety because the proposed amendment is futile. Every category of statement in the second amended complaint fails as a matter of law for one or more independent reasons. The claims are time barred, the content is non-actionable, and plaintiffs have offered zero evidence of falsity or actual malice as to any statement. So we should expect to see 7M's response to that. But let's keep in mind that this has been argued. Clearly, it even went through summary judgment. Certain statements were set to move to trial for a jury to hear. The statements that are in this amended complaint are parallel. They're in alignment. They're defamatory statements just like the first. So the argument that Katie Joy is throwing out here, in my opinion, has already been argued. And the judge has already ruled on those. There's a bigger argument here that Katie has, so we'll get into that as well. But let's move on. This action has been pending since March of 2022, nearly 4 years. Katie's reporting concerned Robert Shin's operation of Shekinah Church and 7M Films, including allegations of cult-like control, financial exploitation of young dancers, and sexual abuse. Since that time, plaintiffs have been the subject of dozens of articles and video stories. A documentary has been made about them. They have become embroiled in litigation against other small content providers, former dancers, and church members. So, first of all, this clearly is not any writing that has been provided before. You could tell that somebody else has drafted this. This is at somebody else's hand, right? And she's arguing, other people have spoken about it. Yeah, but they stopped talking about it, Katie Joy. And they only talked about it in the brief time up front, which is when this original complaint would have covered those statements, right? I think that's why Katie is like, okay, anything that goes in after that, if this amended complaint is granted and she goes through all the rigmarole to get it, booted out, whatever it may be, if that goes to trial and that is what is heard by a jury, she's doing everything to prevent that because the statements that she said after are very damning and, in my opinion, way more defamatory. And there were not a bunch of people talking about it. The docuseries that came out on Netflix, Katie Joy has said she was a big part of that. She provided a lot of the documentation for that docuseries. So what argument does 7M have to say, yeah, well, what came out afterwards was influenced by Katie Joy. So Katie needs this amended complaint to end where it's at, completely be thrown out, and only go back to the original statements that she thought was heading to trial in the first place. She goes on to talk about the total of 46 statements that happened in summary judgment on the June 23rd, 2025 ruling and the December 16th, 2025 ruling. And she's saying, all these statements were dismissed while permitting plaintiffs to move to amend to specify the statements which they claim are defamatory, meaning these last 33, not the initial 13. On February 3rd, 2026, plaintiffs filed the proposed second amended complaint, where instead of specifying the 33 dismissed statements from the December ruling, 7M filed an 87-page document containing 212 separately identified publications spanning from February 2022 through December 2025. And they state that 7M has done nothing to support their motion, saying that there was only a 4-paragraph affidavit from counsel authenticating the proposed second amended complaint, but that there were no declarations, no evidence of falsity has been presented, no evidence of actual malice has been offered. And Katie has said that over and over, and here's her second chance. Now they filed this amended complaint, possibly with better advice here from somebody that might understand defamation a little bit better. She's arguing it a little bit better this time, but the argument's already been made. To me, there's a more of an argument about what was submitted in this amended complaint that Katie should be arguing. But again, she has to argue her stance and say, no, there's no defamation here. I didn't say anything with malicious intent. And she does get into that other argument here in a bit. But again, this is Katie Joy saying that they have not proven defamation and that they don't have a leg to stand on. They say that a party may amend a pleading only by leave of court, and such leave shall be freely given when justice so requires, according to the Minnesota Rules of Civil Procedure 15.01. The liberal standard, however, is not without limits. A motion to amend a complaint is properly denied when the additional claim could not survive summary judgment. And again, I will say, this is my opinion, that this probably would survive summary judgment if the original complaint did and got as far as it did with this court. So I think that is a weak argument, but you have to argue it, I guess, right? An amendment may also be denied when it is a mere rehash of the original complaint or when the proposed allegations are vague and add nothing. So I think that bit from a case study just doesn't really add much here because I don't think it is a rehash, clearly, because she's saying you added over 100 new statements. So I don't know how that's rehash or how the allegations are vague and add nothing, because I think, in all honesty, it's the opposite. They say that because of where this case is, 7M bears the burden of establishing that their proposed amendments are legally viable and supported by evidence. They have not done so. Argument. The proposed amendment is futile as to all categories of statements. And she says, defendants have analyzed every statement in the second amended complaint and organized them into 5 categories based on their procedural, posture, and legal deficiencies. The detailed analysis is set forth in the attached tables A through D. What follows addresses each category with illustrative examples. Across all categories, one fact is constant. Plaintiffs have presented zero evidence that any statement is false. We'll look at those tables very briefly at the end here, but I have to give it to her on this. Finally, information has been categorized and laid out in a way that makes sense and is easy to follow. I'm not saying that her argument is stronger, and I'm not saying that it changes her argument, but it goes to show the difference between what is being presented now versus prior is a huge difference. There was a situation where Jennifer Moore, Katie Joy's attorney, filed this table of information and it was all wrong. And it was very detailed, but it was all wrong. And so she had to go back and refile and say, well, wait a minute, this is wrong. Here it is again. And it was very confusing. And this is laid out differently. Just an observation. But now they address the 13 statements. The 13 statements previously dismissed on substantive grounds cannot be revised by repleading. 13 statements were dismissed on June 23rd, 2025 on substantive grounds, not for lack of specificity. But y'all, that's not the case. That's not the case. The statements did not lack importance or significance. It was because they could not be accessed by the judge. So is a judge going to forget her own ruling here? Is somebody drafting this that Katie did not give all the details to? did Jennifer Moore draft this and she forget? Because that's kind of insulting to the judge, in my opinion. She did not say these comments, these 13 statements that 7M says are defamatory, I'm dismissing them because they don't apply. Like they're not defamatory. They just, no, that's not the case. The case was very clear. They could not be accessed. Okay, moving on. Repleting these statements with additional detail does not address the basis for their dismissal. But does it? Because they couldn't be accessed, but now they can? I don't know. I don't know how the judge is going to see that. But Katie stands by the content of each statement. And then they give an example saying statement number 12 in the First Amendment complaint stated, quote unquote, admitting to contacting the LA Clippers. But in the Second Amendment complaint now provides the actual quote, which reveals Katie Joy said she, quote unquote, spoke to a couple of people that have contacts with the Clippers. The Second Amendment complaint's added specificity actually undermines the First Amendment complaint's characterization and helps Katie Joy. Granted, that one statement, sure, I can see their point here. But this statement 12 is a bunch of statements included in number 12 because it was in a live stream Katie Joy did on her Instagram page. And there are several statements within number 12 that 7M claims are defamatory. And when we go back, I'm not going to do it right now, but when we do go back and look at that live stream to look at what 7M was pointing out for this statement 12, you'll also hear Katie Joy say that they can't, Miranda cannot make her own decisions, that they have to refer to somebody else, and that taking away any of their, or involving yourself in any of their sponsors or whatnot is not a bad thing. So it all kind of circles back, but you have to listen to it as a whole. Their second example is statement 21, characterizing 7M as a cult that is preying on black dancers. It was dismissed on the merits. And they say in the Second Amendment complaint, text is essentially identical to the first by using the word cult, preying on, and exploiting. So let's look at these two just as an example so you can get an idea as to what 7M submitted and what Katie Joy is saying. This first one, 7M is a cult, and the cult is that they are preying on black dancers, exploiting them, and convincing them people don't like them for being black. And there is an error there. I don't know if that's why they tried to amend it, saying that it should not have been dismissed. I don't know. I don't know the technicality on that. But here is what they put in the amended complaint. It's not about race. It's about a cult. The worst part of this cult is that they are preying on black dancers, exploiting them, and then making them believe that everyone is mad at them because they are black. On the contrary, everyone loves the black dancers and wants the cult to stop harming them. And she included the hashtags, #facts, #7M. So the original we saw was dismissed, and 7M has put it back in. I guess to elaborate, we shall see what the judge says. But nonetheless, Katie Joy is saying that the text in the Second Amendment complaint is essentially identical and that it remains opinion characterization. So Katie is saying even if this judge does allow this in the Second Amendment complaint, that it's just her opinion, right? These just remain opinion characterizations. And then she says that those characterizations are now corroborated by the federal indictment. There's that word again, y'all. Indictment. Robert Shin has not been indicted. They say regarding these statements that 7M has offered no new facts, no new evidence, and no argument that the basis for these dismissals was wrong and that the court should deny amendment as to all of those 13 statements. Next, they talk about the 33 statements, and they say the 33 statements dismissed for non-specificity are revealed by plaintiff's own specificity to be non-actionable. Plaintiffs were told to specify which statements in these videos and posts were defamatory. They did so, and the result is devastating to their claims. I just find that funny. They say that these quotes consistently reveal content that is constitutionally protected and non-actionable. And they refer to this table. And they say that many of these express opinion signals. They say that at least 14 of the 33 statements are just Katie Joy's opinion, and that it is textbook protected opinion hedging. They say that at least 10 statements have source attribution, and that the things she said came straight from a source, such as, that's their allegation. I'm not saying they're shell companies. So since it's their allegation and Katie Joy is stating it as her own fact, I guess that's the source's fault and not hers for fact checking. I don't know. They say that at least 7 of the statements are just statements about Paulson herself, such as, getting sued is like a badge of honor. It's entirely about Katie's own legal situation. They then address brand advocacy and say that appears in at least 4 of the statements, and that consumer advocacy directed at third-party brands is protected speech. And they cite NAACP versus Claiborne Hardware. And if the judge didn't see brand advocacy as not being defamatory or could be seen as being defamatory at the first go round, I doubt she's going to change her mind on this one. And then, of course, there's the issue of rhetorical hyperbole, which appears in at least 6 entries, such as, this is a doomsday cult, and a comparison to North Korea. Then they say that no reasonable person would interpret these as assertions of fact. I think people would disagree, especially when in the context of when Katie says it and how she says it. And that's up to a jury to decide. And it seems like the judge was going to allow that one to go to a jury. They just needed to specify it more, which they did. And it's all in black and white, or it's all in audio. They reiterate that 7M has provided no evidence, none, that any of these 33 statements are false. They have not submitted an affidavit, a declaration, or a single document establishing falsity. That alone is fatal. So far, Katie Joy has touched base on these 13 statements that she says were dismissed on substantive grounds. Y'all, that word, every time I try to say it, I say it incorrectly. So if I mispronounce it, I go back and forth, just ignore me. And she says that they have no right to be introduced back in. Then she touches on the 33 statements that were addressed by the court and gave 7M the opportunity to amend. And Katie Joy is saying it should just be limited to those 33. Why are these other 13 added back in? And now we're on part C, where she addresses the 12 surviving statements. And she says that those 12 surviving statements were materially altered, not specified. So the 12 statements that survived summary judgment, that were going on, projected to go to trial, so to speak, Katie Joy is saying that those have been altered, not that they went back and actually just kind of specified on them, but that they were absolutely altered. She says that the court's directive to quote unquote specify addressed the 33 dismissed statements. It did not authorize rewriting the descriptions of statements that survived summary judgment. They go on to say that 7M materially altered at least 8 of the 12 surviving statements. Their example is with the very first statement, statement number 1, that was February 27th, 2022. And they say that the first amended complaint says that Miranda Derrick was, quote unquote, lured into a church. They state that the second amended complaint reveals the actual post says she, quote unquote, allegedly cut off contact, an opinion qualifier invisible in the first amended complaint. And I can agree with that, okay? But we have to also remember, when you look at this second amended complaint, it is extensive. And it really does go back in and specify things that Katie Joy said. So she's pulling out things like this that, it shows, okay, well, they said this in the first one, making it sound really bad, but whenever they come circle back around and put in the real statement, it shows opinion. They give a few more examples, and one is statement number 26, dated March 9th of 2022. And they say that within this post, that it reveals the word resembles, which would be a comparison, not an assertion. And they also say that 7M points out that this post was deleted. But let's go ahead and look at the post as a whole to kind of go back to what I was just saying, that she takes out these little bits, but we need to look at it as a whole, because she's saying the word resembles that they are now showcasing actually shows that it's a comparison, not assertion. But let's look at the entire post. it says fact. Okay, so she's stating this is a fact. Miranda and B- do not have their own homes. Multiple sources confirm to us that the church has them living in a property owned by the church. However, some of the property's records are being held in obscure trust names unaffiliated with anyone at the homes. And then she puts a red flag. Fact. Having a car at age 25 when you are supposedly making bank on social media isn't a gift or a prize. It's a necessity of most working adults. Fact. Managers controlling every aspect of someone's life and not allowing them to make any decisions, controlling their money and relationships while working them to the bone resembles human trafficking. So Katie just asserted, right? She just stated as a fact, it even says the word fact, okay, that these dancers have no free will. They don't make their decisions. They're completely controlled. Their money is controlled. Their relationships are controlled. And then she says, that this resembles human trafficking. But the hashtags say free Miranda Derrick, trafficking, forced labor. Okay. So again, take it as a whole. We'll see what the judge decides. Again, ultimately, that's why I don't want to get into too much detail with all this, because there's a lot for the judge to decide, and it's going to be more beneficial for our time to spend our time once we know what is going to be the new complaint, if a new complaint moving forward. But Katie says that the pattern is consistent, where the first amended complaint used conclusory, inflammatory characterizations of Paulson's speech and actual content, now revealed by plaintiff's own amendment, is hedged, sourced, qualified, and opinion laden. But again, we'll see what the judge has to say. But Katie's saying nonetheless that the court should not allow 7M to rewrite allegations that survived summary judgment. Katie Joy now addresses 8 new publications that were not included in the original complaint. And again, all of these statements, like the 33, then the 13, and then this last 12 that we just went over, and now these 8, they each have their own corresponding chart that is attached. So these 8 new publications within the first amended complaint time period are time barred and cannot relate back. So now she is going to bring in the statute of limitations and say that these statements, particularly now we're going to refer to these 8, should not be introduced because they are outside of the 2-year statute of limitations for defamation in Minnesota. And it's kind of a 2-part thing here, but she's saying that these are entirely new allegations that were never part of the original action, so therefore you can't be adding in new stuff because of the statute of limitations. And that the problem with 7M's attempt to specify their claims now is that they are attempting to breathe life into a legal nullity, and that defamation is not a notice pleading cause of action where a plaintiff may gesture vaguely at harm and fill in details later. So I see their argument, but again, look at it at its entirety, right? And we talked about this in our last video, that Katie Joy would more than likely bring up statute of limitations. And there's a lot to kind of go over here. And I think that I'm going to kind of skip over it pretty quickly, because the more I say, I think the more confusing it will be. But basically, Katie Joy is talking about relation back and how 7M has produced this new material, whatever, that it does not, why it should not apply. And as much as I could go back with examples and compare certain things, I think it's just going to be too confusing. It's just too much. And nonetheless, why waste all that energy whenever it might not even be granted anyways? So we'll just wait to see what the judge says, that if these new statements are going to be allowed in because they relate back to the original claim. And so Katie Joy says that by introducing specific quotes and entirely new content now, 7M is not clarifying an old claim. They are attempting to initiate 33 brand new causes of action long after they have expired. So again, saying statute of limitations, they can't go back and redo everything. They were just granted the ability to clarify. But we'll wait to see what the judge determines. But Katie continues the argument by saying that 7M cannot bootstrap 33 unpleaded defamatory statements onto conclusory references to quote unquote various video recordings simply because both involve the same YouTube channel. And I'll just say that when I went to compare and to look at the statements, that some of the statements, it's not just that, oh, okay, she's going to say they relate back because it's the same YouTube channel. There's a lot of things that were brought back in that were related to the same post. For instance, Katie Joy made a post, but then in the Instagram stories, which were eventually deleted because they only last so long, in the Instagram stories, she elaborated on things and said some more defamatory things. Those things were brought back in. That's one example. But Katie Joy is saying, no, you're trying to bring in all 30 new causes of action because they weren't touched on. But again, this is up for the judge to decide. We'll see what she says in regards to the statute of limitations on this. But Katie says, regardless that even setting aside the procedural bar, all of these 8 entries are independently non-actionable because she says opinion signals appear in at least 6, brand advocacy appears in at least 3, source attribution appears in at least 2. And these terms, opinion signals, brand advocacy, source attribution, has never been brought up by Katie Joy, Jennifer Moore in the past. This is clearly a new take. My opinion is that it comes from another attorney that Katie Joy might have assisting her in this, whatever it may be. Jennifer Moore has taken it on. She, I guess, agrees because she filed this and signed it. So it's considered her work, right? But nonetheless, it goes to show there's been a shift here and there's been a change. And, maybe it's just a little too late. I don't know. We'll see. One of the other things we talked about in the last video, outside of the statute of limitations that Katie Joy would probably use as an argument, we knew that she was going to bring up the new anti-SLAPP law that was passed in May of 2024 in Minnesota. She brought it up in one of her videos. It's very clear that she was going to use this as a defense. And here she brings up 6 statements in the limitations period before the anti-SLAPP effective date and say these 6 statements are non-actionable because the second amended complaint entries of these statements fall between February 4th, 2024 and May 23rd, 2024 within the statute of limitations, but before May 24th, effective date of Minnesota's anti-SLAPP statute. So 7M filed their new motion to amend the complaint on February 3rd of 2026. The statute of limitations is 2 years in Minnesota. So that means anything prior to February 3rd of 2024, Katie can say is outside of statute of limitations. Here she is saying there are 8 statements that fall in this weird window, this tiny window between the statute of limitations to where these statements could apply. However, they overlap with the new anti-SLAPP law. And Katie then says that even in this narrow window, 7M cannot state a viable claim because at least 3 entries in the second amended complaint, numbers 93, 95, and 96, which we're going to look at in just a second, contain no factual assertions about any named plaintiff and are entirely about Paulson's own activities and advocacy. Here is number 93 in the second amended complaint, and it's just this highlighted portion that 7M has included. And this portion says, reporting on cults can be very taxing on my mental health. Additionally, the smear campaigns led by cult members against reporters can be overwhelming. It continues to say, the amount of money that I've spent on frivolous lawsuits in the past 5 years is more than I ever expected to spend. The goal for some is to destroy and bankrupt me. Despite their attempts, I will not stop reporting and helping to bring light to darkness in our society. Again, just what's highlighted is what 7M is focused on. Here's number 95 and what 7M included. It's this entire statement that says, not me pitching a new docuseries to 2 separate production companies. Oh yes, that's exactly what I did today. A story that needs exposure. The real story. They said they were super interested. And under that image, the post says, and the only part that they added is highlighted here, and they wanted to emphasize where she said, I can't share specifics, but I have hope this specific group will finally be exposed and the victim will get justice. Number 96 says, it's coming. It's time for the victims' voices to be heard and time for accountability. No more hiding in the shadows, Robert Shen. Your days of harming people are over. And then all of the hashtags, which kind of create their own little story within themselves because there's hashtag Shekinah Church, hashtag Robert Shin, hashtag 7M Dance Crew, hashtag Colts, hashtag Coming Soon, hashtag Dirty Robber, which is who created the Netflix docuseries, hashtag Free Miranda Derrick, hashtag Time's Up for You. So in regards to those three statements, Katie Joy says they contain no factual assertions about any named plaintiff, even though she named Robert Shin, and she's got the hashtags for Miranda Derrick, Robert Shin, etc. That no factual assertions about any named plaintiff and are entirely about Paulson's own activities and advocacy. So take that as you wish. The remaining three, numbers 94, 97, and 98 from the Second Amendment complaint, contain opinion, source attribution, hedging, and express opinion disclaimers. None contain the kind of verifiable, unqualified false assertion of fact that the court has required to survive summary judgment. So let's take a look at these three statements. Statement number 94, it's the highlighted section here that 7M addressed, and it says, I have been designated a point of contact for updates on Miranda Wilking and her involvement with an alleged cult for more than 2 years. It then goes to this highlighted portion that 7M included. Just because you have only heard about the Wilkings doesn't mean this story is about them. In fact, this story encompasses more than 25 years of trauma and victims. There are faceless individuals that have been exploited and harmed, immigrants that have been forced into green card marriages, marriages that have been arranged. All of this is documented in court records. This is not a harmless group. This is a sophisticated group that premeditated this plan years before they found the dancers. They were looking for entertainers for years to do this to. They hit pay dirt during the pandemic. Dancers were out of work and they needed income. Feeling unstable and insecure about their careers, these dancers were vulnerable. So Katie says that all of this is documented in court records. The court records that Katie Joy has is a lawsuit filed against Robert Shin that were technically all accusations, and he won that lawsuit. He was not found responsible for the claims accused against him. Regardless of what the reason is, it still would be considered an accusation because those statements were never verified as factual. So again, you can take that as you will. And on statement number 97, the highlighted portion that they introduced is, Robert Shin is suing me, and one of the statements he claims damaged him is that someone was, quote unquote, waterboarded in his church. The statement is from his praise team during a service in January 2020. This is a clip from their now deleted SoundCloud account. They believe in healing, money, and apparently dumping water on people during service. He will, of course, deny these claims and state that this recording is not from his church. Now, I do know that this was brought up at some point in summary judgment, and the judge actually sided with 7M on this, stating that the words were misconstrued and I need to go back and look at all the details and how that correlates here, but I do know that it was brought up. That's all I can say right now I don't want to state something as a fact and then be incorrect. But with this post, Katie Joy included a recording during service where Katie Joy is accusing him of waterboarding, and that term is a very serious term to be using, especially when it doesn't align with the audio. But Katie Joy and her followers, once Katie Joy said it, her followers just believed her. And it's wild because you can hear the audio and it really doesn't correlate. But nonetheless, Statement 98 says, there is also a likelihood that Robert Shin will sue Netflix and the production companies as an attempt to reclaim the narrative, in my opinion. It's a game for him, in my experience. I've dealt with him for 2 years in court. Everything I've experienced from him in court and online has been a game. He monitors my reporting. Court records indicate that ex-dancers learned about his misdeeds through reporting and then came together to share their experiences. The overwhelming takeaway was that all of the ex-dancers that left had been misled, defrauded, and one of the females alleged sexual battery. Robert has attempted to sue me for public statements other people have made and court allegations from public filings. There will be a huge push to make it seem like they are all free and capable to do as they wish. The propaganda will likely get worse leading up the series. This should be ignored, discounted, and understood as a lie. The truth that will be revealed is devastating and horrific. It's worse than anything I could have ever reported on my own. All of this will be revealed and more. And obviously she's referring to the Netflix docuseries that was about to be released, which was released in May of 2024. And you can come to your own conclusion on that. But again, referring to those three statements, Katie Joy says that they contain opinion, source attribution, hedging, and that they express opinion disclaimers. Katie Joy says that she stands by every statement in this window that these 6 statements fall within, and that 7M has offered no evidence, no declaration, no affidavit, no document establishing that any of the statements is false, and therefore the amendment is futile. Katie then continues to talk about the 113 statements that were made after the anti-SLAPP was introduced into Minnesota, and it says that the largest category is the most straightforward. Every one of the 113 second amended complaint entries published on or after May 27th, 2024, postdates the effective date of Minnesota's anti-SLAPP statute. Each statement was published on matters of public concern, specifically reporting on an ongoing federal criminal investigation into sex trafficking, financial fraud, and coercive control. First of all, Katie Joy is not privy to what the exact criminal investigation is about. Okay, let's just be clear about that. When Robert Shin was raided, the people outside the church, which is one of Robert Shin's properties that was raided, there was media and there were people, and it was stated this property belongs to the man that is the focus of the Netflix docuseries where they say he is a sex trafficker and other things. Just because some bystander said that to some media outlet and that got carried on does not mean that that is what he was being investigated for. That's still an unknown. The accusation in the docuseries, that's an accusation. Okay, yes, there are people that come forward and said X, Y, and Z, but that does not mean that that is what he is being investigated for. So for her to say that, anti-SLAPP occurs because she's, covering this serious matter of public concern, when in all reality, she doesn't even know, nor does anyone truly really know, other than Robert himself and, law enforcement and his attorneys, what he's truly being investigated for. But Katie goes on to argue that everything she has said would be protected by the anti-SLAPP statute, which is made to protect people from being wrongfully sued just to silence them. And Katie Joy has said time and time again throughout this lawsuit, her argument has been that Robert Shin has just wanted to silence her. And if the courts agreed with that assertion, Katie Joy wouldn't be where she's at. This would not have carried on as long as it has. Clearly, there's more to it than Robert Shin just suing her to silence her. Katie Joy even went as far as to say that the court deemed her a journalist, therefore she cannot be silenced. But that is not what happened. And in the summary judgment, the judge even says that Katie Joy identifies as a journalist. Not that the court identifies Katie Joy as a journalist, but that Katie Joy identifies herself as a journalist. But Katie says that the amendment to add these claims is futile because each will be subject to a special motion to dismiss under the anti-SLAPP statute. So she's saying, you pass this, I'm just going to file another motion to dismiss. None of the 113 statements contains a verifiable, unqualified, false assertion of fact about a named plaintiff that could survive the statute's threshold. And I think that if the other statements have survived as far as they have, there's a great chance of this as well. But of course, that's not for me to decide. We'll wait to see what the judge says. But here is the situation, y'all. This would be the first time, not only for this court, but from my understanding, the entire state of Minnesota, that a situation arose where there was a current lawsuit that was in current litigation for defamation that had already been in for 2 years when the anti-SLAPP law was passed. So there's no case study. There's no reference to say, okay, well, does anti-SLAPP apply to these statements that were entered after the fact? The first would be grandfathered in, so to speak, but the statements that they're trying to put into this amended complaint after the anti-SLAPP was passed in Minnesota, how does that work? And so Katie, to some degree, might have a little bit of an upper hand in this situation. I think more just to buy her time, because honestly, in my opinion, Katie's best ally here is time, because she is banking on the fact that Robert Shin is going to be indicted. Clearly, she's using that word throughout this filing here, but she goes on to say that statements about herself, her litigation experience, her costs, etc., that appear in 30 of these entries cannot be defamatory. And also that petitioning activity where she calls to contact the LA district attorney, the sheriff's office, the FBI, the IRS, U.S. attorneys, that appears in at least 20 entries entries, they say that this is constitutionally protected petitioning, and they cite the NAACP versus Cleburne Hardware Company. She's trying to say that the anti-SLAPP would protect her because she's just reporting on public records, the federal raid, search warrant contents, which she does not know search warrant contents. That is not public information to know. So to report on search warrant contents would be reporting on false information, wouldn't it? And she says also to report on deposition testimony. In this case, the deposition testimony is under a protective order, so it's sealed. If they're referring to other cases, possibly, also court rulings, federal forfeiture notices, and that these appear in at least 25 entries, and that fair and accurate reporting on public proceedings and records is privileged. But it's not fair and accurate. And I think 7M has been successful in proving that prior, and I think they're going to be just as successful moving forward if this amended complaint is granted. She says that also under the anti-SLAPP, she would be protected by consumer advocacy that calls to unfollow, boycott brands, and not engage with dancer social media, which appears in at least 15 entries. But they say that brand boycott advocacy on matters of public concern is constitutionally protected. And same with opinion and rhetorical hyperbole, such as her statements that said Robert is dangerous, or doomsday, calling it a doomsday cult, or that he is a menace to society, or a weak little boy. These are classic non-actionable characterizations, Katie Joy says. But for somebody who claims to be a victim of Robert Shen, that she's so terrified of Robert Shen because he's caused her so much fear and anxiety, but she's going to call him a weak little boy, just doesn't add up. Again, taking everything into the full context. And luckily, this judge is familiar with the full context. It reads differently. So Katie Joy says that within these 113 statements, that they have not proven that any of the statements are false, nor have they provided any evidence of actual malice. And permitting an amendment would serve no purpose except to generate a special motion to dismiss under the anti-SLAPP statute. And we said this in my last video as well, that I didn't think that she was even going to respond to this. I thought she was just going to wait for the judge to grant it, because more than likely that does seem to be what will happen, that she was just going to go straight to filing this special motion to dismiss. But she filed this. She's arguing why these new statements should not be allowed in to this case, that the jury should not see these. I mean, I'd be terrified if I were her. I wouldn't be her because I wouldn't be in this position, right? But she cannot have these statements in because it is damning. And here's the thing. These statements that she says after the fact are even worse. They look worse. They're more directive. She states so many more things as fact. She needs them out. So again, we'll see what this judge says, but Katie is saying that she absolutely should be protected by the anti-SLAPP statute. And if this judge does decide to grant this amended complaint, she's just going to file a special motion to dismiss, which is her right. But she says that if that were to happen, that would be a burden to the court and impose additional costs on defendants, and therefore the amendment is futile. The amendment exceeds the scope of the court's directive. And she's just reiterating here that the 33 statements dismissed for non-specificity was not authorized to just do a whole new repleading, right? And that what 7M filed is a new complaint that expands from approximately 85 statements to 212. And that's a 149% increase. That it adds entirely new publications that were available but never pled. And it adds 113 post-anti-SLAPP statements. So statements that should be covered by anti-SLAPP that have nothing to do with the court's directive to quote unquote specify previously dismissed statements. Plaintiffs have presented no evidence to support any claim in the second amended complaint. And again, they're saying there's been no declaration from any plaintiff. There's no affidavit addressing falsity. There is no document establishing that any statement is untrue. There is no evidence of actual malice, that Katie Joy knew any statement was false or entertained serious doubts about its truth. Katie Joy stands by her reporting. Her reporting has been corroborated by a federal indictment. No, it hasn't. Plaintiffs have not identified a single statement in the second amended complaint that is demonstrably false, much less presented clear and convincing evidence that Paulson published it with knowledge of or reckless disregard for its falsity. And this will be an argument that we will see 7M make, and we'll see how the judge rules on it. They say this applies specifically to the 113 statements that were made post anti-SLAPP. Now, every one of the 113 post anti-SLAPP statements in the second amended complaint concerns reporting on an active federal criminal investigation into sex trafficking, financial fraud, and coercive control, quintessential matters of public concern. Again, we just went over how I feel that's a little skewed. If these claims are added by amendment, each will be subject to a special motion to dismiss, and plaintiffs will be required to make a threshold evidentiary showing they have not even attempted here. Plaintiff's motion to amend does not acknowledge the anti-SLAPP statute, does not address whether any of the 113 statements could survive the statute's threshold showing, and does not offer any evidence that would satisfy it, permitting amendment to add claims that will immediately be subject to dismissal under the anti-SLAPP statute, generating 113 claims worth of motion practice with a foreseeable outcome, does not serve justice. It compounds the burden this litigation has already imposed on defendants and the court. So they reiterate that without evidence of falsity or actual malice as to any statement in the second amended complaint, no claim could survive summary judgment. And for the post anti-SLAPP claims, no claim could survive the statute's threshold showing. Amendment that cannot survive summary judgment is futile. Well, this is a whole separate situation, right? This is a new complaint that would be referred to. But if it's on the same grounds as the first, then yes, I would say this could survive summary judgment. That's just my opinion. We'll wait to see what the judge decides. So this next part is quite interesting, and it says request for certification under Rule 54.04. Should the court grant any portion of plaintiff's motion, defendants respectfully suggest that it might be appropriate for the court to certify 2 questions for immediate appellate review under Minnesota Civil Rule of Procedure 54.04 and Minnesota's Civil Rule of Appellate Procedure 103.03. And they pose these 2 questions. Question 1, whether a district court has a constitutional gatekeeping obligation to independently assess the sufficiency of evidence of actual malice before permitting amendment of a defamation complaint to add new allegedly defamatory statements where the plaintiff is a public figure or the speech concerns matters of public concern. So Katie has the right in Minnesota to request this trial court to certify with the Court of Appeals for an immediate review, like any important or doubtful questions of law. So before this judge makes a final judgment. So if this judge agrees, she would issue a certificate, outlining these 2 questions that Katie Joy has presented here. And while they're waiting for the pending ruling from the appellate court, the case may be stayed. And that's just giving Katie Joy more time, right? So this could be strategy, but also it does seem true that this law isn't reasonably clear because there are no existing statutes or case law to refer to. So by Katie Joy requesting this from the court, typically from what I've read in Minnesota, judges are not likely to agree to certify questions. But in this situation, as we stated before, I could see that this judge might have reason to. Or this is also showing that Katie might have good reason to appeal later on down the road. So I'm curious to see what this judge does from here. The judge has been, in my opinion, quite fair in ruling. Katie Joy disagrees, obviously. So that's why I'm so curious to see what happens with this. Question 2, whether Minnesota's anti-SLAPP statute that was effective May 24th of 2024 applies to claims added by amendment to a complaint originally filed before the statute's effective date, where the amended complaint is filed after the effective date and the newly added statements post the date of the effective date. And they say both questions present issues of first impression in Minnesota. No Minnesota appellate court has addressed the application of the new anti-SLAPP statute to an amended complaint filed after the statute's effective date when the original complaint predates it. So I am curious to see, is this judge going to refer to the appellate court, or is she going to say this trial court has the authority to make this decision regarding this amended complaint? It's going to be very interesting to see. And they say that if the Court of Appeals accepts the anti-SLAPP question, it will necessarily need to address the actual malice gatekeeping question as well, because the anti-SLAPP statute requires plaintiffs to demonstrate a substantial basis in fact and law, a showing that necessarily implicates the actual malice standard. So it's very interesting here because Katie Joy clearly has had assistance in this. I don't see Jennifer Moore drafting this. I just don't. And how far that assistance goes, it's none of my concern, right? Nonetheless, Jennifer Moore has presented it and signed it, and she's standing by this as her work. It's just very interesting to see where this may go because, again, this is a new situation in Minnesota as a whole. And are they going to say this trial court did not have the authority to make this decision and it should have gone to the appellate court early on and it didn't? So we'll see. I do not know if this judge has had another case within her court that the anti-SLAPP applied. So, it could be the judge say, look, I don't feel that this case would survive anti-SLAPP. Like, no. So then would this be necessary? Probably not. So Katie Joy is just giving all her options because what else do you do at this point? She is doing everything to keep these statements from going to trial. But they say that certification would serve the interests of justice. A stay pending appellate review would avoid the substantial cost and burden of litigating claims that may be subject to dismissal as a matter of law, would provide guidance on an issue that will recur in Minnesota courts, and would allow the court to proceed on a clear legal foundation. In conclusion, the court should deny their motion to amend in its entirety. Every category of statement in the proposed second amended complaint fails as a matter of law. And they continue to say that Katie Joy stands by her reporting because her reporting has been vindicated by federal law enforcement action. Y'all, federal law enforcement action. He's not been arrested. He's not indicted. There are no charges. He's being investigated. No one knows what the investigation truly consists of and why it was initiated. 7M has told this court that they feel Katie Joy is behind the initiation of the raid and the investigation, and that if it weren't for Katie Joy Paulson telling everybody in her social media posts to contact every form of law enforcement, then he would not be under investigation. Okay, so here, once again, they're trying to tell the court, look, the law enforcement action proves that Katie Joy has told the truth. This vindicates her. And I absolutely disagree. We'll see if the judge does. Permitting amendment would serve no purpose except to prolong litigation that plaintiffs have been unable to support with evidence for nearly 4 years. No, they have provided it, and it's headed to trial. It was projected to head to trial. Now, this new amendment, we'll see what happens. Is this judge going to grant this new amendment? And then, if so, how much of it? And then, obviously, we know what Katie's going to do. She's going to file a special motion to dismiss, and we'll see what happens. There are still 2 motions that the judge will be ruling on. That motion hearing was held in February, and we'll see where it goes from here. Now, I'm not going to go through this in detail, but I am going to include it for those that would like to read it in full. Attached is tables A through E, and each table goes over the certain group of statements that we just covered. And each table will have a color-coded system, so to speak, that Katie is saying applies to each statement that she made, whether it's opinion, source attributed, whether it's about Katie herself, substantially true, whether it could be found in public record. She referred to this as public record, therefore anybody could find it, but there are issues, obviously, that we went over regarding this whole situation referring to public record. Also coded is non-party, brand advocacy, duplicative, and mapping error. And it's laid out quite nicely, I have to say, in comparison to things that we've seen in the past. But Table A goes over the dismissed statements, right? So the 33 statements, they start out with the 13 statements, and then it goes on to the 33 statements. And you can pause. It's going to go pretty quickly here, but you can pause and look at them and see. Now, this is something I will be going over eventually once we know what the ruling is regarding this amended complaint. So if it strikes your interest, go ahead and pause. If not, we will go over it eventually. Again, does this stick? We We don't know. But it does go through each and every statement, obviously, the 13 statements and the 33 statements, and then they color code it. And then to end it, after this table is complete, it offers a summary of findings and goes through, everything that, how many were opinion and etc. From here, it goes on to Table B, which covers the statements that survived summary judgment. Again, here's the analysis tags for this, and then it goes through the 12 statements that survived summary judgment that 7M said they went and respecified, even though they really weren't supposed to, and that by doing that, actually, it hurt 7M more. I don't know. Regardless, it also ends up with its summary of findings, and you can look at this if you choose. I have not put much time into this. I really haven't even looked at this aspect of it to see what Katie is saying. I will look at it briefly, and then that'll be it, because I'm curious to see what the judge has to say. Plus, I've read these statements so many times. I have cross-referenced to all of the posts, all of the videos, etc. So I'm kind of over all these statements. We get on to Table C, which are new statements added to the proposed second amended complaint within the first amended complaint time period. Same thing, analysis tags to address those 8 statements that 7M states are new and, again, should not apply due to the anti-SLAPP and statute of limitations. They include the significance here. And again, this is very well laid out and thought out. It's a shame that it's happened this late in the game, but, and I don't know how strong the argument will be to this judge, but then we get on to Table D, which includes the new statements added in the proposed second amended complaint post-dating the first amended complaint. Again, I know this is going pretty quickly. If you wish to pause. And I'm trying to wrap it up because I said this was going to be a quick video, and here I am in over an hour, but it was a lot to cover. I thought I was going to be able to do it quickly, but I was wrong. So anyways, Table E are the new statements added in the proposed second amended complaint post-dating the effective date of Minnesota's anti-SLAPP statute. There are quite a few of these. This is quite long, so I'm going to let it run out. You guys can pause it or you can stop it whenever I'm done talking, whatever you choose. But I thank you for being here. Thank you so much for joining. As always, I appreciate you, appreciate everything you do to support this channel. I look forward to seeing you in the comments. I look forward to seeing you in chat on my next live. If you're watching from the bushes, that's fine too. Again, I thank each and every one of you. I hope you have a wonderful rest of your day, and I'll catch you on the next one. And if you made it this far, there's probably only one of you that did.